Well, anyway, the case gets to the Supreme Court, and there are dozens and dozens, as there are in these controversial cases, of amicus briefs. And not that I read them all, but I followed them. And there wasn't a single brief. There was a brief by the legal historians. There were this and that and the Constitutional Law Society and all that stuff. And not a single one of them could cite a case throughout the entire history of England before 1789 where the writ of habeas corpus reached beyond the sovereign territory of England. So while the case was pending, I gave a few speeches at law schools. I didn't predict the outcome, but I did say to the students that there's no way that the Supreme Court can get around this history. No way. I was wrong. One of the classic books on historical research and analysis is by David Hackett Fisher, and it's entitled Historians' Fallacies. In his book, Professor Fisher lists 112 common logical fallacies in historical scholarship. By my count, the majority opinion in Boumediene manages to commit 47 of them. And I'll give you just the following illustration. The majority states, Lord Mansfield can be cited for the proposition that at the time of the founding in 1789, English courts lacked the power to issue the writ to Scotland or other regions beyond England's sovereign territory, which Lord Mansfield referred to as foreign. Now notice the phrase, Lord Mansfield can be cited for this proposition? The greatest lawyer in England, the Lord Chief Justice of England and Wales, it doesn't prove the proposition? I noticed that Lord Mansfield's name is graved in stone on the outside of the University of Pennsylvania Law School. When you go back that way, you can look up. Anyway, the Supreme Court attempts then, it's an opinion by Justice Kennedy, we've heard about him today, attempts to blunt this history by noting, quote, the possibility that English courts were motivated, quote, by prudential concerns rather than formal legal constructs. And, Justice Kennedy adds, by the way, Lord Mansfield made a mistake. Scotland wasn't foreign, it was part of Great Britain by that time. That still left a question under the suspension clause. If the writ of habeas corpus applied, did Congress's action in the statutes overruling the Supreme Court provide an adequate substitute for the writ of habeas corpus? And those statutes, in a nutshell, said all the detainees get kind of a military commission review or military tribunal review, and then there's review of that in the DC Circuit on the record. So that's the substitute. By this time, I think the justices in the majority had grown weary of originalism, because you cannot answer the question I just posed without knowing what the writ of habeas corpus encompassed. Forget about how far it reached, what it encompassed in 1789. But the Supreme Court majority never told us. That was the focus of Chief Justice Roberts' dissent. It never says what the writ is. It just says that what Congress supplied was not good enough. And we're going to leave it to the judges of the District Court of the District of Columbia and the DC Circuit to figure out what the content of the writ of habeas corpus is, or was, or should be, with no guidance whatsoever, except maybe the history. And our court now has hundreds of these cases. I heard one just last week, trying to figure out the latest issue, which I won't go into very much. It just was the burden of proof? We don't know. Does the executive have to show some preponderance of the evidence, clear and convincing, proof beyond a reasonable doubt that the detainee was somebody who's a bad guy, was an enemy combatant, or is it simply enough that the government produced some evidence? How do we decide those questions now that the Supreme Court has pronounced that the history of the writ of habeas corpus, the content of it, is unimportant? I don't know. I think one thing I do know is that George Orwell was right. He wrote, quote, who controls the past controls the future. Who controls the present controls the past. It's easy to distort history. Professor Fisher gave us 112 different ways that historians do it, perhaps unknowingly. And there are many, many others. Originalism cannot confine the judiciary. The best the Boumediene majority could do was find ambiguity. But once having found that, none of the 5 justices in the Supreme Court majority had any expertise in foreign policy, in the security of the United States, in military affairs, or anything related to the imprisonment of the detainees. And I think that what the court should have done if there had been ambiguity, and I don't think there was, I don't think there was genuine ambiguity, is follow what Judge Wilkinson suggested, and I'll end on this note. He said, and this is like the 14th Amendment in the Commerce Clause cases and the, with economic regulation, deference to the legislature. He said, when a constitutional question is so close, when conventional interpretive methods do not begin to resolve the issue decisively, the tie, for many reasons, should go to the side of deference to the democratic process. Thank you very much.